morning, everybody. Morning. Thank you all very much for coming today. For those of you who don't know me, my name is Grant Campbell. I'm a partner here at Brodies, specialising in information and technology law. This session will be given by myself and my partner, Martin Sloan. Could I start just a few words about the cameras at the back? We are not expecting Prince Harry and Meghan Markle. We're live streaming this session, but you are not being recorded. The focus is very much on us. And when it comes to the Q&A session, the cameras will be turned off. So we want people to interact and we don't want people to feel inhibited. So this session is about GDPR and a data protection update. It is part of the Be Informed regular series of updates that we do. So what we wanted to cover today is this. So GDPR, we'll start with GDPR, 6 months to go. We'll talk about GDPR in the context of Brexit, what we see is happening in that context. Talk about the UK Data Protection Bill. So there's a bill currently going through Parliament that will sit alongside GDPR, and we'll explain a little bit about what it says. The regulators are also active, so we'll talk about new guidance that's been issued by the Article 29 Working Party. We'll also talk about the e-privacy regulation, which is like the little brother to GDPR. So there's another piece of European legislation coming down the track, which may or may not come into force in 2018, that you need to be aware about. And beyond that, we'll talk about other just data protection issues. So there's a number of other significant developments that anyone who is active in this field needs to be aware of. And then finally, we'll talk about cybersecurity, because there is another European directive coming down the line next year that will be relevant to security, particularly in relation to infrastructure. So there's quite a lot to get through in the course of the next 45 minutes or so. So without further ado, I said there was 6 months to go. I lied. There is slightly less than 6 months to go, 177 days to be precise. So time is marching on. We want to talk about GDPR. Now, a lot has been said about GDPR, and this is not the seminar to go through it in detail. But what it is the biggest shake-up of data protection law in almost 25 years. GDPR is a new EU data protection law which will have direct effect in all EU member states. I'll talk about Brexit a little bit later. It enters into force on the 25th of May 2018. And what it should do, what the regulators and the legislators hope, is it will offer greater consistency in terms of treatment across Europe, provide a stronger and more coherent data protection framework, but it will also have teeth. So it will be a regulatory framework that is backed up by pretty severe sanctions for breach. What it will also do is it will involve the Data Protection Act 1998 being repealed. So for those of you who actually deal with data protection law now and know the 1998 Act well, that will be repealed in its entirety. It will be replaced, and I'll explain with what shortly. So for those of you who are new to GDPR, and I'm conscious that there are people who are still, and organisations that are still thinking about GDPR, there are a number of things to be aware of. Firstly, it's evolutionary. So many, for example, of the key concepts that we have in current UK data protection law are retained in GDPR. So we're still talking about personal data, which is data about identifiable living individuals. We still have the concept of sensitive personal data, although it's now called special category data. We still have processing, so the regulation covers everything from the point where personal data is obtained to the point of its destruction. And again, mere holding of data is a regulated activity. We still have the concept of data controllers, and we have the concept of data processors, though there are new obligations for data processors. The data protection principles, so the 8 data protection principles that we have under the current legislation, are still recognisable, although they've changed the number, there's now 6. But there is specific reference to transparency and accountability, and these are very, very important concepts in understanding GDPR. The conditions for processing, so the justifications for processing, are still similar, but there are some changes. Individuals still have their own data subject rights. So the rights are broadly recognizable, so subject access, rectification, these things, but there are some new ones. The laws on international transfer, so the route to be able to transfer data outside the EEA, still broadly the same. The standards for data security, a little bit more explicit, but broadly set at the same level. But there are new mandatory data breach notification requirements, which all organizations need to be aware of. The other thing that's still the same is we will still have the same regulator. So the Information Commissioner's Office will still be the regulator for data protection in the UK. But I think it's fair to say it will go from being a Cinderella regulator to be a regulator with real teeth. So whilst the regulator remains the same, the regulatory environment changes. What's changing? Well, rather a lot is changing. I mentioned transparency earlier, so there are enhanced fair processing requirements, which means that really you're going to have to put more into your privacy statements. You're going to have to be more upfront with people when you collect their data. The concept of consent is tightened. It's also going to be, you're also going to have to make it as easy for individuals to withdraw consent as it was to give it. And I think that means that consent is going to be much more fluid than it was previously, particularly since you'll have to tell people that they have the right to withdraw their consent at any time. The obligation is not only to comply with GDPR, there's an obligation to demonstrate compliance. So organizations will have to be able to discharge an onus that shows that they are actually compliant. Use of privacy impact assessments will be mandatory. There'll be need for training, and there will be need to make sure that all of your policies, not just having a data protection policy, but all of your policies, incorporate privacy and data protection requirements to the extent that they're applicable. There are increased administration and record-keeping requirements. The enhanced rights under GDPR include stricter rules on subject access, but also the right to be forgotten and data portability. The organizational principles of data protection by design and default, which have always been seen as good practice recommendations, get hardwired into the law. Data processors will have statutory responsibilities for the first time. So up till now, data processors have only ever had contractual responsibility to their controllers. Under GDPR, they will have statutory responsibility to comply with various aspects of GDPR, including data security. I mentioned mandatory breach notification. So if you've got serious data breaches, you will have to notify the regulator that they've happened. You may also have to notify the individuals concerned. The last thing that I really wanted to mention was the sanctions. So the maximum fine for contravention of GDPR is 4% of turnover, or 20 million euros. Now, 20 million euros is about 17 million pounds. So the potential for very, very serious breaches is for a much, much higher fine. Now, our expectation is that the regulators are not going to be looking to levy maximum fines for anything other than the most serious breach. Their fines have to be proportionate, but they also have to be deterrent. So we expect to see that the ICO will look to flex its muscles. And of course, because it has to act in a way that's consistent with all the other regulators, it will have to make sure that the fines that it issues are in line with those that are being issued in Europe. A question that's often asked now is, what if we've yet to do anything about this? What if we've yet to start? Well, we set out above on the top of the slide a kind of process methodology that really is quite straightforward. First thing you need to assess is what impact GDPR is going to have on your organization. You have to work out what it is that you're currently doing and prepare a gap analysis between what you're currently doing and what you think GDPR is going to require you to do. And once you've worked out what that gap analysis is, then you've got to plan a strategy. You've got to plan a strategy to fill in those gaps. and then you have to implement it. And once you've implemented it, then you have to assess whether or not you've properly implemented it and whether all the gaps that you identified have been plugged and whether there are any other gaps that have come to light subsequently that you need to plug. And you have to keep doing that until you actually get to a point where you feel comfortable that you are compliant. We've set out, and there are various papers on your seats, we've set out in a basic steps guide the things that we think people should be doing. So here are our top 5 recommendations. Firstly, on resource, you have to prepare a team and you have to prepare a strategy. So you need to work out within the organisation who is going to actually take responsibility for your GDPR project. And that needs buy-in at the top, because that team will need resource and they will need the rest of the organisation to take them seriously to ensure that the project is actually implemented. They'll also need budget. The second thing you need to do is data mapping. Now, this can be a very, very large and complex exercise, but at its core, what you need to do is you need to understand what data you have, why you have it, and what you do with it. And you want to make sure that that ties in with what you tell people you're doing with their data. So when you collect it, what you tell them you will do with it. So you need to do that. Data minimization, it's a great opportunity. GDPR is a fantastic opportunity to cleanse your data, to get rid of all the stuff that you have accumulated over the years that might just be useful one day and you've never looked at. So this could be, we're focused on GDPR on personal data, but look at all of your data and think, actually, we've got a whole load of stuff that may be sitting in storage off-site and we've not looked at in many, many years, or we've got stuff in archive that we've not looked at in many, many years, and think about whether you need it, whether you can justify continuing to hold it, and if you don't need it, then actually think about getting rid of it. And going forward, make sure that you have appropriate data retention and destruction policies to ensure that you only keep the things you need for so long as you need them. You need to review your processing justifications. So review the justifications you have for what you do with people's personal data. Look at your privacy statements. Do you have a lawful basis for actually doing what you're doing? That may be particularly relevant in the context of consent, because you may have consent now on the current law, which is not actually going to work under GDPR. So you may need to think about what it is that you're actually doing to refresh that consent in time for GDPR coming in. And then the final top recommendation is your contracts. Look at your contracts. Make sure that they are up to date. Do they contain, where they're processing personal data, do they contain all of the mandatory requirements that GDPR has? That may affect directly your processing contracts, but think more widely. Does it affect, for example, your technology contracts? Are your technology contracts impacted? Is indeed your technology fit for purpose to comply with GDPR requirements to the extent it handles personal data? So all your technology needs to be GDPR ready. More detail on all these recommendations is set out in the handy guide that was on your seat. You can find it at that link. The other thing that we've developed, just again by way of a plug, is we've developed a self-assessment tool. It's an online tool that helps organisations to answer and consider all of the GDPR issues and to identify where those gaps are. So it helps with the first 2 stages of the process, and it allows you then to be able to prepare a prioritised action plan of all the things that you're going to need to do going forward. So what are the key actions? Well, appoint or resource your team. If you need a data protection officer, then make sure that you have one. I think in the market at the moment, there are a limited number of people who have the expertise and a lot of people looking for DPOs. So you may need to think about whether you need to grow one internally. Is there someone who has the skill sets and who could be grown into becoming a DPO? You need to review and update your privacy notices to make sure that they comply with all the new requirements of GDPR. I mentioned earlier, if you're relying on consent, particularly for direct marketing, then actually you need to have a strategy for refreshing those consents if those consents don't actually meet GDPR requirements. GDPR requires consents to be given on a kind of opt-in basis, which means you need affirmative action. So, for example, if you've constructed a database on the basis of pre-ticked opt-in boxes, that won't work under GDPR. So if your consents are not going to be GDPR compliant, you need to review them now and think about whether there is either another basis on which you can do what you're doing, or alternatively, if you have to rely on consent, how you can get people onto GDPR compliant consent in the 177 days which remain. IT projects will be impacted, so you may need to re-engineer your data collection forms and some of the privacy controls around your apps and your websites. You may need to review and reconfigure your IT systems. And also remember that there's these new and enhanced rights for individuals to ask for certain things about their data. If your systems are processing data, are they capable of actually responding in the way that's required to these new rights? Also need to start thinking about what records you're going to have to keep. You may need you're likely to need a data processing register. So this is a register of your data processing activities. Where you actually outsource processing to others, you may need a register of your data processors. You need to make sure that if you're having to repaper your contracts, that you're getting your contract amendments in place. So that may involve dialogue with a number of people with whom you deal. It's not always the quickest process to do. To the extent you need to repaper your contracts, you want to be thinking very much about getting that process started now. You may need to update your policies and procedures. Again, as I said, it's not just a case of having a data protection policy. You need a full suite of policies and procedures, and you need to make sure to the extent data protection and privacy is relevant that it's covered. And you need a staff training and awareness process, because ultimately your staff are your first line of defence in any compliance exercise. Now, it doesn't mean that staff need to know everything about GDPR, but they do need to know how GDPR affects what they do on a day-to-day basis. And that may vary. So the people who man your desk may need to understand what a subject access request actually is. They don't need to know how to deal with it, except they need to know who to pass it to. And they need to know that it needs to be done quickly. They also, all staff need to know that if they lose personal data, they have to report that centrally so that the team can swing in and actually decide how they're going to cope with the incident. How can we assist? Well, we can assist in a number of ways. We can assist with documentation. There's a lot of documentation that's required, and I've listed up there all of the sorts of things that most organisations are likely to need as part of a GDPR project. But we can also assist, as you would expect, with consultancy. So we can advise on the legal bases on which you process data. We can help with drafting privacy statements and consent forms. We can help with policy and document reviews. Clearly, contracts are something that lawyers deal with regularly. We can help you with that. We can also help with training and ad hoc queries. I mentioned earlier the self-assessment toolkit. Our hub, which is available at that link, contains a running commentary of all the things that are happening in data protection. So it's a useful resource. It's free. You can go in and just browse and hopefully find things that are useful. So, Brexit and the UK Data Protection Bill. As you may have heard, we are leaving the EU, apparently. We will be, GDPR will be enforced before we do. So GDPR will come into force in the way it was always intended, by direct effect on the 25th of May 2018. Once we've left the EU, how are we going to be treated? Are we going to be, for data protection purposes, just another third country, like a South American country or an African country? Are we going to be treated in the same way as that? Or are we going to have something else? Well, the government, in its repeal bill, so this is the widespread, the wide-ranging legislation that deals with European law as a result of our leaving the EU, says that legislation that has direct effect, like GDPR, will become national law. And so GDPR will continue as part of national law after we leave the EU. In terms of data transfers, the government set out its position. It's seeking an immediate adequacy decision. So for those of you who deal in data protection law, at the moment, within the EEA, data is freely transferable. The fact that we are in a different member state country makes no difference. So as part of the single market, personal data can flow freely. When we leave the EU, we will be outside that single market. But there are a number of countries who have demonstrated to the EU that they protect personal data to at least an equivalent standard as the EU, which means that the EU will allow free transfers of data between the EU and those countries, almost as if they were part of the EU. We will be looking, the UK government's made its position clear, we will be looking for an immediate adequacy decision, which explains why the UK government have been keen to adopt GDPR and make it clear that when we leave the EU, GDPR will be incorporated into national law. It's to reassure the Europeans that actually our regime for data protection will be every bit as good as theirs. I'm getting a little bit of politics here. I think the sticking point probably is two things. One is we would like our regulator, even though we're outside the EU, to have some influence in terms of how data protection law changes over time, and I think that may be something that's quite problematic for the Europeans. Also, the other sticking point is at the moment, under GDPR, ultimately data protection issues would be a matter for the European Court of Justice, and clearly that is a political line in the sand for the UK government. So there are some issues that will still need to be worked through, but that's what the UK government's position is. We want frictionless transfers of data between ourselves and the EU. Then there was an announcement by the Department of Culture, Media and Sport that effectively UK data protection laws were going to be overhauled and that we would have a new UK data protection bill. And the Digital Minister, Matt Hancock, made a very grandiose announcement about all of this. Almost, it was like the UK government was claiming authorship of all of GDPR, and slightly facetious slide here, which is the signing of Magna Carta. Almost felt a little bit like that, and we've got Matt Hancock there. If anyone can spot, there's a number of reasons you can spot this as a faked image. The one that I liked the best was that the new data protection bill is considerably longer than Magna Carta, which has been signed in that image. And it is a bit of a behemoth. So it's 194 clauses and 18 schedules. It's currently wending its way through the House of Lords. If I can, sure this will show on camera, but GDPR, UK Data Protection Bill. It's a much more lengthy tome. So why is it so complex, and what does it say? Well, it's divided up into a number of parts, and it's probably helpful if you're ever having to tackle that to understand broadly how it works. So part 2 of the legislation deals with general processing, and that is what is likely to concern almost everybody in the room. There's separate sections on law enforcement, separate sections on intelligence service processing, so that's MI5, MI6, their rights, etc. Part 5 deals with the Information Commissioner, what that office is, what the regulatory powers, etc. are. And then Part 6 deals with enforcement. So, Part 2 of the bill, this is the bit that deals with general processing. Now, if you're looking at the legislation, it's slightly confusing because the Part 2 is divided in itself into 2 parts. So there's Chapter 2 and Chapter 3. Chapter 2 applies to processing which is within the competence of EU law and therefore directly caught by GDPR. Now, it's important to understand GDPR has direct effect. Until we leave the EU, GDPR has direct effect, which means that the UK government doesn't need to do anything to implement it. Indeed, it can't do anything to implement it because it is a law that has direct effect. So when it legislates around GDPR, it has to go, it's like a door ring. It can't actually legislate over GDPR. It has to supplement it where it's allowed to. It can derogate from it, but it has to work around GDPR because GDPR has direct effect in the UK. Chapter 3, because the EU doesn't have unlimited competence, Chapter 3 deals with areas that are outside the competence of EU law. So broadly speaking, what the UK government has been trying to do is to set up two regimes. One, which is the one that we all expected, which supplements GDPR, but the other one is a kind of parallel regime that is broadly equivalent, that sets up the same sort of regime for areas that are outside EU competence. Now, we didn't have this with the Data Protection Act 1998 because the UK Parliament legislated for all of it because it could. The direct effect of GDPR means that it can't legislate over GDPR. It has to legislate around it, but only insofar as it's competent for the EU to legislate. That's quite a complicated explanation, but broadly speaking, what the legislation is trying to do is to ensure that for all processing, we have a broadly GDPR equivalent scheme. So hopefully that makes a bit of sense, because when you look at the legislation, if you have to, it is really quite complicated to understand, but that's why it's done the way that it is. So what I want to talk about is the provisions in the bill that deal with supplementing GDPR. So this is for the vast majority of processing that all organisations do. GDPR will directly apply, and these provisions in the bill are intended to supplement GDPR. So firstly, GDPR left it open to member states to decide who was or was not a public authority. So the UK government have now prepared draft legislation that says, broadly speaking, if you would be a public authority for the purposes of freedom of information legislation, whether the UK freedom of information legislation or the Scottish freedom of information legislation, then you will be a public authority for the purposes of GDPR. Now, that has a number of impacts. Firstly, if you're a public authority, you must have a DPO. Secondly, if you're a public authority, you are not entitled to use legitimate interests in the performance of your tasks. The intention being that you should have some form of statutory basis to justify your processing. So it's important now we know what the UK government's intention is regarding public authorities. Secondly, what Chapter 2 does is it amplifies a number of provisions in GDPR. So, for example, GDPR says under Article 6.1e that you can process for public interest tasks or in the exercise of official authority. And now what the bill says is this is what this means in a UK context. So you can process for the administration of justice, you can process for parliamentary functions, you can process if you're a government department in pursuance of these functions. So we're getting more granularity through the bill as to what GDPR actually means in specific areas. Where there is digital services or information society services, the legislation says that children at the age of 13 can consent. The default was 16 under GDPR, but member states could reduce it to 13. The UK government has signalled its intent to do that. Schedule 1 to the bill is quite lengthy, but what it does is it includes quite a significant number of additional justifications for processing special category data. So this is information about health, trade union membership, sexual life, all of the stuff that we know is sensitive personal data. There is a raft of processing justifications contained in Schedule 1. There are supplementary provisions dealing with data subject access requests. So I said that GDPR itself tightened the rules on subject access, but it also gave, whilst it abolishes the right to charge £10 for just dealing with subject access requests, there are provisions that allow controllers to charge for unfounded or excessive requests, and the UK government can legislate through regulation as to what charges can be levied. And then there's additional safeguards on automated automated decision-making in Clause 13 of the bill. Note that if you are relying on substantial public interest justifications, you can only do that where there is an appropriate policy document and other safeguards in place. And again, the legislation sets out what's required. What the legislation also does is it contains, in Schedules 2, 3 and 4, various exemptions and derogations. And in doing this, it's relying on Article 23 primarily, GDPR, which allows member states to create exemptions and derogations from GDPR in specific areas. You can go through those at your leisure because they are quite detailed and complex. But there are various levels of exemptions, starting from crime and taxation. So if you're processing data for purposes of detecting crime, for tax purposes, there are exemptions there. If you're processing for regulatory functions, again, there's specific provisions relating to that. And then there's some of the exemptions that we know and love from the 1998 Act in terms of, for example, third-party information, how you balance the rights of those who are exercising subject access against the rights of third parties whose information may be wrapped up in that. And there are also various exemptions which are currently found in Schedule 7 of the DPA. So for confidential references, management information and forecasting, all these things are still there. But then there are specific exemptions in Schedule 3 for health, social work, education, and child abuse data. And in Schedule 4, and this shows how, the world has moved on, we've now got specific provisions dealing with things like human fertilization, which way back in 1995, when the current legislation was dreamt up, there was no specific provisions dealing with that. So there's a bit of an overhaul. And then finally, just really to just underscore this point, we have these two kind of separate regimes, or two parallel regimes under the bill, one dealing with stuff that's within the competence of the EU and legislating around that, and then this parallel regime that seeks to create a broadly equivalent regime for stuff that's not directly caught by GDPR. And the government signalled its intent that when we actually leave the EU, what it plans to do is to simplify this and effectively create a single regime based around GDPR. So this complexity that we currently have in the bill and in the legislation, they will use their powers, which they hope to still have in the EU withdrawal bill, to amend the regime to actually create just a single regime which will apply across the board when GDPR no longer has direct effect. So what I'll do at this stage is hand over to Martin. And Martin is going to start talking about latest regulatory guidance.
Thanks, Grant. Good morning. So what I'm going to look at over the next few minutes is just some updated guidance that we've had since the last update that we did in the spring. There's been a few things that have come along. So firstly, from the Article 29 Working Party, which is the EU-level body made up of the Information Commissioner and the fellow regulators and all the other member states, have issued a couple of bits of draft guidance. We've had some guidance on notification of personal data breaches and also in relation to automated decision-making and profiling. So I'll talk a little bit about those. They've also now finalised the draft guidance on data protection impact assessments, and that was something we spoke about in the spring as well. So that is now in final form. And also in terms of timetable for upcoming guidance, we have been told to expect guidance on consent, transparency, data transfer tools, administrative fines, and also something in certification, which will come in 2018. Now, I suspect, like me, you feel a lot of this stuff can't come soon enough, and I think part of what we're seeing here is, as Grant said, GDPR is a regulation and there's a consistency mechanism to ensure that all member states enforce it in a consistent manner. And the reason for the delays in this guidance is the different views of different regulators in different countries where there are different approaches to data protection. So, for example, the regulators in France and Germany are far more pro the individual compared to the UK, where the Information Commission has been much more pragmatic, taking a much more pragmatic approach. And I think what we're seeing here is it's just taking time to actually reach a landing between all the different regulators in terms of the approach that they'll take. So, first bit of guidance to look at is on breach notification. So under GDPR, data controllers are obliged to notify the supervisory authority, so that's the Information Commissioner in the UK, of a personal data breach, unless it's unlikely to be a risk to the individuals concerned. And some very helpful draft guidance from the Article 29 Working Party on this. So they set out 3 different types of breaches to consider. So firstly, you've got confidentiality breaches, where someone who shouldn't have had access to that information gets access to it, whether that's because it's unauthorised or an accidental disclosure. Secondly, there may be an availability breach, where you're no longer able to access that information, whether it's permanent or temporary. And thirdly, there's what they call an integrity breach, where the accuracy or the completeness of that information has been in some way affected. And the Article 29 Working Party takes a very broad view of this. So, for example, a ransomware or a malware attack, and we've seen a lot of that this year, could well tick a number of these boxes. Availability breach, if you suffer a malware attack and your systems are encrypted by some malware, then that would be an availability breach. You can't access that information for a period of time. It may be permanent or it may be temporary. But it could also be a confidentiality breach because someone who shouldn't have had access to that will have access to it. It's a very broad interpretation there. And in terms of looking at when an organisation is considered to be aware that they've suffered a personal data breach, there's a little bit of leeway here. So the Article 29 Working Party says it's at the point at which you have a reasonable degree of certainty that something has happened that's led to the information being compromised. So although you have to report it within 72 hours, there's a little bit of time to actually try and work out what has happened before you're considered aware. But the sting in the tail is that the Article 29 Working Party's draft view, and that this may change in the final guidance, is that if you're using a data processor to process data on your behalf, then because a processor is essentially doing stuff for you, you are considered to be aware as soon as they're aware. So that's quite difficult. If you've got another organisation who is hosting a system for you or running a service for you, doing something, and they suffer a data breach, then what the Article 29 Working Party says is that as soon as they are aware, you as the controller are aware, and that's when the 72-hour clock starts running. So that's something to think about in terms of your contracts with data processors about what you say around data breach notification and what they should be doing, how much assistance they should provide. I know that some processors are trying to push back on obligations to report data breaches or putting a timescale on it, but I think this just emphasises how important that is. And the guidance goes on to provide some factors for determining what is risk and high risk. And high risk is relevant because if there's a high risk individual, then you also need to notify the individuals of the breach. So what sort of factors might you look at? First of all, you've got the type of breach. So unauthorised access may give rise to greater risks than that information being lost or destroyed. Again, it depends on what form it's in or what's happened to it. But also the nature of the information, the sensitivity of it. So, for example, disclosure of health data is likely to have a much higher impact on an individual than, say, just their name or their email address. And again, looking at the sensitivity, the volume of that as well. Also looking at things like ease of identification. So if only a few identifiers have been disclosed, there may be a lower risk than, say, if lots of identifiers have been disclosed, or something that is particularly unique and allows the individual to be identified. And again, things like encryption and pseudonymization are potentially helpful here in reducing the risk to individuals. And again, looking at what the impact is to the individual. So what might happen as a result of that? Could they suffer identity theft? Could they suffer fraud? Could they suffer distress? Might that data be used maliciously against them in some form of ransom or whatever? So again, looking at the impact of it is very important, not just what data's gone, but actually what the impact is on the individual. And also thinking about which individuals are involved. So it might be vulnerable people, or it may be children, or other groups where there may be a bigger impact. And finally, thinking about your own characteristics as an organisation. So a breach affecting a hospital may give rise to much greater risks than, say, a marketing business or someone who just holds, let's say, maybe email addresses or something like that. And so taking this all together, I think what comes out in this, what's important, is that as an organisation, you need to have in place a fairly detailed breach notification procedure so that when you suffer a breach, firstly, you can identify it quickly, secondly, you can take steps, but also you can actually work out fairly quickly what the risk is to the individual and therefore whether you need to make a notification. Okay, the second bit of guidance that we've had from the Article 29 Working Party looks at automated decision making. So under Article 22 of GDPR, individuals have the right not to be subject to decisions based solely on the basis of automated decision making where that has a legal effect for them or otherwise similarly significantly affects them. And a lot of people took that to be a right to object, because Article 22.2 then goes on to say certain conditions upon which it can be done. But what the Article 29 Working Party has said is actually that right not to be subject to this, in their view, is a prohibition. So it's not a right to say, I don't want to be subject to automated decision making, but actually you cannot do it unless you are doing it on a basis that's necessary to form a contract, or it's authorised by law, or it's based on explicit consent. So that potentially, for any organisations that use automated decision making, could be an issue in terms of how you use that in your business, because certainly I think most people were surprised at the view in the draft guidance that this is an absolute prohibition. And of course, as with all things in relation to data protection law, where there's a reference to necessary, that's always interpreted very narrowly. There must be no less intrusive means of actually carrying that out. So where it's necessary for the performance of the contract, is there actually no other way in which you can make that decision other than using automated decision making? The guidance provides some examples of what might be meant by legal effect. So for example, if you have a mobile phone account and you fail to pay your bill and it's automatically switched off because you haven't paid it within a certain period of time, that would be considered to be a legal effect or a similarly significant effect. Similarly, things like profiling individuals, say when they arrive at a border, applying for credit, that kind of things, but also online advertising could have an effect on an individual. So the example given is if you serve up adverts to someone, encouraging them to gamble, and they actually have a gambling addiction, then that could have an impact on that individual, which the Article 29 Working Party says would be regulated here. And that's very difficult to actually know whether the individuals in question would actually have a gambling addiction, but you might just serve them adverts based on profiling that's done, say, well, they're interested in gambling. And also potentially online profiling that leads to individuals being provided with different pricing as well. Is another thing which could affect an individual. So if you charge people different amounts based on automated profiling and decision making, that could be covered by this as well. The requirement under Article 22 talks about decisions made solely on the basis of automated decision making. What the guidance says is any human intervention here has to be actually meaningful. You can't just have someone who nominally oversees what is being done. They actually have to be involved in making that decision. So perhaps they're given the information following the analysis, the automated decision making, and then they then go on to decide, actually, I'm going to follow that, or we're going to do something different. But you can't just have someone there who nominally supervises what the computer is doing. And I think for me, what this highlights is the importance of data protection impact assessment. So if you are using automated decision making, actually carrying out a data protection impact assessment on that before you do it, so you can work out what the risks are and what your legal basis is for doing that, whether it's regulated under Article 22. So that's the Article 29 Working Party Guidance. What's the Information Commissioner doing in this country? Well, we had some draft guidance on processor contracts back in September. In my view, it wasn't terribly helpful in terms of taking us further forward in terms of what we should put in our contracts. It kind of avoided providing guidance on some of the difficult issues like how much detail you go into around security measures. That has gone through a consultation process, and we'll be publishing further guidance on that in due course. You may also remember from our spring update that we had some draft guidance on consent earlier in the year, and we were told that that would be finalised over the summer. Back in about September time, the Information Commissioner changed the timetable on its website and said actually that won't be to the end of the year. And this all comes back to the fact that the Article 29 Working Party hasn't yet set out its position on consent. Therefore, the Information Commissioner cannot finalise its own position because whatever it says has to set within the boundaries set by the Article 29 Working Party's guidance. So we're told that should be the end of the year, but given we've still not got the Article 29 Working Party's guidance, it remains to be seen if that moves back further. For those of you who are in public authorities and have been grappling with the legitimate interests condition and the changes that Grant talked about on that, you'll be pleased to hear that the Information Commissioner is promising some guidance on that early in the new year. So if you're a university or a body like that that carries out some things which are not perhaps traditional public functions, then we're getting some guidance which should hopefully explain what these hybrid bodies are able to do in terms of legitimate interests. And we'll also get some guidance on the Information Commissioner's enforcement policy under GDPR. But I think perhaps the most interesting thing they've been doing over the last couple of months is encouraging industry and industry bodies to actually get together and develop industry-specific guidance. So one of the things under GDPR that you can do is you can have codes of conduct which are approved by the regulator. And what the Information Commissioner has said is that they just don't have the staff to be actually able to produce guidance in a lot of areas for a specific industry. But what they're more than happy to do is a particular sector wishes to come up with its own guidance, say for data sharing in the public sector, or say financial services, how that interacts with your FCA rules, come together as an industry, produce some guidance that you agree on, and send it to us for review, and then we can, if we're happy with that, we'll sign off on that. And it's a really good tool for actually industry taking the lead in terms of compliance and what they think is appropriate. And the Information Commissioner is very, very open to that. So if you're in any sector where you think that sort of approach would be helpful, then do get together with your peers and see if there's a way to come up with some guidance, because the opportunity is there. Okay, the other bit of legislation we have on the horizon, as Grant mentioned, is the e-privacy regulation. So at the moment, marketing by email and by text message, marketing calls as well, are regulated by a bit of legislation called the Privacy in Electronic Communications Regulations, which sits alongside the Data Protection Act. And in January of this year, as you remember if you were at our earlier session, the European Commission published a draft e-privacy regulation, which would sit alongside GDPR and update the rules on electronic marketing. So for most electronic marketing, the good news is a lot of this is likely to stay the same. So marketing by email or by text message, you will still need to have consent. That stays the same. And soft opt-in to be able to market to people to whom you've provided goods and services previously stays the same as well. But what does change is that the definition of what is consent points to GDPR. And as Grant said, the rules on consent are changing quite a lot. So if you currently issue electronic marketing to your customers on the basis of consent sought under the old legislation, it's likely you're going to need to look at what you do going forward in terms of updating those consents to ensure that they're valid under the privacy regulation. And that will require a bit of strategy and a bit of thinking about actually how you approach that, because a number of organisations have been tripped up by trying to actually get fresh consent, but ending up actually sending marketing messages to people for whom they haven't actually got consent to market, and find themselves in big knots and then being fined by the Information Commissioner. The other good news from the privacy regulation proposals is that the rules on cookies will hopefully be simplified, so that annoying banner adverts that we get on all websites will hopefully disappear, and we'll be moving towards browser-based controls. So actually on your device you will say what sort of cookies you're happy to accept and control it there, rather than having lots and lots of messages which don't actually tell you a huge amount on the website. And there's likely to be some new rules on marketing telephone calls as well, coming in as well. Where are we in this? Well, the Article 29 Working Party published its opinion back in April of this year. They broadly welcomed the proposal, but they were concerned about tracking walls where you could only access a website if, say, you accepted cookies, which has an impact for online advertising where it's based on tracking across different websites. They thought the individual should have the right to access a website but not be subject to online tracking, and that clearly conflicts with the advertising industry's current moves towards using more and more behavioural advertising. The European Parliament followed up with similar views in terms of pushing for some stricter rules. So where we are at the moment is that the Commission, the Parliament and the Council are now away to actually try and agree a final text. Now, the Commission's original plan was that this would all come into force at the same time as GDPR in May next year. Clearly that's not going to happen, and it looks like we may have an agreed text by June of next year, with the new rules to come in maybe in 6 to 12 months after that. So it's very much watch the space. But as you are preparing for GDPR, it makes sense to think about e-privacy as well, rather than have to repeat this exercise 6 months down the line, because it's really all tied up together. Okay, what other developments have we got? Just a couple of bits of guidance that you may have missed over the summer with GDPR. Firstly, the Article 29 Working Party has issued updated guidance on monitoring of employees. So this builds on a 2002 opinion, so 15 years ago. And it really just emphasises that if you are monitoring employees, and that's very broad, it's not just monitoring what they're doing in IT, but also use of vehicles, use of devices, use of access cards to building, all that kind of stuff, then consent is not a valid or appropriate grounds for doing that. GDPR makes that pretty clear, that employers can't rely upon consent as basis of processing if the employee doesn't have a choice as to whether or not to actually accept what is being done. So it's important to look at other grounds for processing, such as it's necessary for the performance of an employment contract, it's within your legitimate interest, or you're doing it to comply with your legal obligations. So again, it's important to carry out a privacy impact assessment to actually work out, if you are doing monitoring, what your legal basis is for that, ensuring that it is lawful. There's some very helpful guidance in the guidance on things to think about. So, for example, monitoring of social media, carrying out checks before someone joins an organisation, tracking of vehicles as well, all that kind of stuff is covered in the guidance. So do have a look at that. Some slightly unusual conclusions. So the guidance says that those messages you get from DPD, saying when Dave is going to come and deliver your parcel between 11 and 1 o'clock today, they're suggesting actually that is providing too much information and would be unlawful if you can track where a particular individual is. But it's certainly worth looking at to think about how you use tracking as an organisation. The other bit of guidance we've had, and this is from the Information Commissioner, is on subject access requests. So earlier this year, there were a number of cases in the Court of Appeal which overruled the guidance that the Information Commissioner has issued on subject access requests. So that led to the Information Commissioner updating the guidance over the summer, and a couple of helpful things for organisations that deal with subject access requests. Firstly, the provisions dealing with disproportionate effort apply not just to actually making information available, but also potentially to finding that information in the first place. And that's been something that organisations have struggled with, is the cost and effort of actually searching email archives or retrieving boxes from storage, whatever it may be. What the Court of Appeal said is actually that can be covered by the disproportionate effort exemption. But it's not an absolute right for refusal, so you have to actually go to some effort to show why it would be disproportionate to go and carry out those searches and show you've taken all reasonable steps, and also engage with the individual in terms of refining that search. But it is helpful in terms of reducing some of the burden in terms of subject access requests. The guidance also says that the motives behind the subject access request are not relevant in deciding whether or not to respond to that. But it does acknowledge that the courts have a discretion as to whether or not they actually order an organisation to comply with a subject access request if they decide not to do so. And you'll see on the screen there some of the factors there. In particular, whether there's an abusive process, whether there's a more appropriate route disclosure. These are factors that a court might want to take into account when, if you as an organisation decide not to disclose information, they might say, well, actually, yes, we're not going to order you to do that because there's a more appropriate way. Say you're in the midst of litigation and the litigation process is a better way to actually disclose that information, or using a subject access request would somehow abuse that process. So again, all of this is quite helpful for organisations dealing with subject access requests. Data protection fees. So the current notification fees will disappear under GDPR. That doesn't mean to say there'll be no fees payable. There will be some new rules coming early in the new year in terms of the new regime, which was created by the Digital Economy Act earlier this year. It looks like it will be a 3-tier system, and that will go live on the 1st of April. In the meantime, when you get your renewal letter from the Information Commissioner asking you to pay your £35 or whatever the fee is for your organisation, you should just pay that, and the new system will come in next year. And on international transfers, just a quick update. Privacy Shield has been through its first test. We're a year down the line. The Commission has said that's still fit for purpose, though whether a subject to legal challenge remains to be seen. Just to be aware that there is more litigation involving Max Schrems, who was the individual who brought down Safe Harbour. He's now suing in relation to the use of standard contractual clauses, and that's now gone to the European courts. So we expect that to be heard possibly next year at some point. Watch this space on that one. But again, it just, I think, emphasises the importance of thinking about what your strategy is for international data transfers, where you're holding data, and what the risks are to your organisation if the legal basis is undermined by one of these cases. Conscious of time, I want to leave some time for questions here. The last section was dealing with data security, so just have a look at the slides in the pack, and I think we'll maybe just skip through to questions. But just as I go through that, just helpful to look at a recent case involving the WannaCry attack earlier this year, where the National Audit Office criticised what the Department of Health had or hadn't done in relation to preparing the NHS for that. And it's pretty clear that these risks were known, but steps weren't taken to actually install patches to deal with some of the malware attacks that took place. Why is that relevant? Well, shortly before that, we had an enforcement notice against Gloucester City Council dealing with a similar attack a couple of years ago, where they failed to update their systems following the Heartbleed attack, and they lost a large amount of sensitive personal data. Just to emphasise the importance of good cyber risk management here, going back to the breach reporting obligations, the importance of actually ensuring you have proper data security, all of these things, when you are dealing with your systems, making sure you actually are patching them regularly, because it's pretty clear that if you don't do that, you don't follow the guidance from software vendors, from the ISO as it comes out, and that will lead to enforcement action. I'll skip over the NIS directive again, just interested in getting to questions. That's some links there to the hub which Grant mentioned, and also to our blog and Twitter account. We have 5 minutes left for questions if you want to go that, and I think the cameras will stop rolling now, so do feel free to ask any questions you want without fear of it being recorded for posterity.